Well, I guess we should start this party off. Hello, everybody. How are you? It's Dave Neal, stand-up comic, host of Bachelor Nation News, and we've got our Patreon audience that we were just hanging out with is now going to be joining us here on the public channel. So spend a few minutes letting you guys get all caught up. Beautiful day in Western New York, says Janice Baldwin. Good to hear. Let me know where you're coming from. Diane is in Boston. How are you, Diane? You ready for a live stream, kid? So yeah, we're going to have a lot to talk about. Tiffany's buttering her breadsticks. I don't know if that's a metaphor or if that's what you're doing, but either way, we are here for you. We're happy. Butter those breadsticks all you want, old Tiff dog. So I've got the a notice of change of judge for cause memorandum and affidavit. So we'll be sharing that. It's 211 pages. I hear, though, it's really only the first 25 or so pages. So we'll share that. We'll just give you guys a couple minutes to get situated, join us, and then we'll move it all along. I shared on my Instagram. Let's see if I can find it here. I shared on my Instagram a clip from this morning's podcast. So I will play it for you guys right now, which kind of sums up my thoughts on the matter. It's only got 4 comments, which, look, I understand these types of reels don't always do well because it's not a visual thing. But if you guys don't mind and want to either share it or like it, it'll probably be good. I'm sure whenever you're talking about controversial things, they tend to get sort of silenced by the algorithm, and I get it. But either way, here's what I had to say. Continues to talk about me. He says, I do not personally know Dave Neal, but during the course of this proceedings, I've become generally familiar. According to his YouTube channel, Dave is a stand-up comedian who lives in Tennessee, also creates and publishes videos on YouTube nearly every day. Dave's videos often focus on The Bachelor and people like Clayton who have appeared on the show. All right. Yep, that's what I do. Kind of hardworking. Over the last several months, Dave has obsessively published hundreds of hours of videos regarding this case, again, often on a daily basis, as reflected on his YouTube channel below. These videos are generally almost universally devoted to viciously attacking Laura and often me, and to proclaiming that Clayton is a victim who deserves justice. Notably, Clayton has personally appeared in several of Dave Neal's videos, and it is clear that Dave Neal is not covering this case as a neutral journalist, but rather as a passionate, obsessive advocate for Clayton. My response to him, go fuck. He continues to talk. I love a good censor. All right, so I have an idea. We're going to possibly refute his claim right now, but let's go to our good friend Schnitzel. I think they have, no, it's not Schnitzel, Ninja. I think our friend Schnitzel has the latest case, right?
I was talking to...
So what we can do here is we can look at the transcript and it'll literally show moments where people are speaking. So we'll show the transcript here. We'll let that populate. Teresa said records are broken in Palm Springs. Tiffany said, viciously attacking, dramatic much? Litigious people like to know where people live. Janice says, I don't follow you on Instagram. Oh, you got to follow me on Instagram. Look, I got to tell you, our Instagram, and we'll let people, there's only 230 people here. You know, we should be getting close to 1,000 for a video like this. So let's just, everyone hit the like button. My Instagram has had a crazy week. We went from 25,000 followers to 42,000 followers. Look how many views these reels are getting. I made a video where I called out people who bring their cell phones for their kids to the restaurant, and I triggered almost 250,000 people. And I say triggered because some of the comments are hilarious. It's basically a bunch of addicted people saying why it's okay to have cell phones in your... I get it. We've all, whatever. But I had this video take off 4.6 million views. Anyway, we don't need to cover all of that. Just showing you how, it's nice to be on that side of the algorithm, as it were. Okay, so why don't we start from the beginning? Why don't we just get into it, shall we? We will cover as much as we can get into here over the course of the hour. And then I'm going to be going back to Patreon where we'll make the podcast. Cece said, Laura has given Gingras instructions. Ruin Dave Neal at all costs, and Dingus is trying to deliver. Laura is the puppet master, and Dingus is the puppet. Yeah, the funny thing is, and I've reminded them this all along, it's just not a game they can win. What can she do? Like, we're on the right side of the story. We have the ball. They cannot stop us. The offense is too good. MG Law said, of course he is obsessed with you. Which of us isn't? Thank you, MG Law. I appreciate that.
Dave coming with receipts.
I clipped this. I have a new sound bar here from Reality Steve.
Dave coming with receipts.
So there it is. Dave coming with receipts. So he'll be coming around the corner with receipts. He'll be coming around the corner with receipts. He'll be coming around the corner. He'll be coming around the corner. He'll be
Dave coming with receipts.
Around the corner with receipts.
Dave coming with receipts.
Okay. Anyhow, let's just get into it. So hit the like button. 280 people. We'll see how many folks we can get. I understand. I know a lot of people in the Clayton case might think this story's over, but it's just not. Now, I got an email from someone just a few minutes ago. They're actually on their tractor. They said they can't fact check this because they're on their tractor, but they say one of Gingras's claims they actually refute. So we'll have a look at that. Sunshine says Laura is obsessed with Dave, so her guard dog Dingus has to be too. I don't disagree, and I don't mean to make myself the center of attention here, but boy, it's almost like, did I date this girl and not remember? Did I break up? Were we at a high school dance and I said no to her once? Like, what is you know what I mean? Now, I know for a fact I've never met her, but I'm just saying, move on, lady. So anyway, let's get into it. Are you guys ready? We all buckled up? Are we buckled up? Oh, Chris Jenner with $2 super chat, greasing the old wallet. The first super chat spot is mine. Mwahaha, says Chris Jenner. I have a photo of Chris Jenner. I don't want to out you, but I never shared these photos that I had from the trip. Can I share it? See if I can find it. So many photos. I don't want to share it if she doesn't want me to. I have a lot of photos from that trip. Where are they though? That's the question. I'll wait for consent if I get it. We got a photo at the pizza place. Maybe we didn't. Oh, there it is. Oh, here it is. This is fun. Okay, they're not good photos. Whoever took these, they're not good. I'm going to share it anyway. Can I share it? Let me know. I'm ready. We're anxiously awaiting Chris Jenner. Yeah. Oh, Chris Jenner says, release the photos. So how about this? This is me autographing. Put this in the court documents. This is me autographing. And by the way, a very cool tie-dye shirt. It said, proud fan of Dave Neal, some podcaster. And then I signed it right there. How nice is that? Heartbreaker got the best of me.
Dave coming with receipts.
Coming with t-shirts too. All right, let's get into it. You guys ready? We've jabbered enough. We're up to 350 people. Maricopa County Superior Court, State of Arizona, notice of change of judge for cause, memorandum and affidavit in support. Noticed Judge, Honorable Julie Mata. Presiding Judge, Honorable Rhonda Fisk. So this is, I would like to speak to your manager. So if somebody could make me an AI song called Gingras would like to speak to your manager, this is him saying, I don't like the answer I got from the waiter, in this case, Honorable Julie Mata. I would like to talk to the manager, in this case, Honorable Presiding Judge, Honorable Rhonda Fisk. Chris said, can you send me those, please? Yes, sorry. Oh, yeah, I got CJ said, the reason Laura's obsessed with Dave is because he exposed her scam. Yeah. She's kind of stuck onto me the way things stick onto people, you know? All right. Pursuant to Rule 6.1, Arizona Family LP petitioner Laura submits the following notice of change of judge for cause and memorandum and affidavit in support thereof. As explained below, there is clear and convincing evidence demonstrating the judge currently assigned to this matter, Honorable Julie Mata, is biased, prejudiced, and has engaged in conduct which violates both Laura's right to due process of law under both the U.S. and Arizona constitutions, and which separately violates Rule 2.9a and 2.9c of the Arizona Rules of Judicial Conduct by inter alia performing an independent investigation into the facts of this case, considering and relying upon information posted on the internet about this case, and engaging in ex parte communications regarding this case with her father, Harry L. Howe. This conduct, while sufficient to warrant additional other relief, including but not limited to a new trial, establishes grounds to disqualify Judge Mata on the basis of bias and prejudice within the meaning of ARS 124095. For these reasons, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and to find that grounds exist to disqualify Judge Mata and to promptly reassign this matter to a new judge. Laura wants to speak to the manager. JH with a super chat says, confused, decision made. Can only appeal now? Question mark. I don't know. I don't know how much merit this has. What happens if, can you imagine, while I do appreciate the judicial system and the checks and balances, I can't imagine Honorable Rhonda Fisk throwing a colleague under the bus if it's not totally sufficient. Like, I could see if we find out Judge Mata, put it this way. You've got the Supreme Court who literally goes on vacations with billionaires and they don't get in trouble. Samantha said, so funny that Dingus and Laura don't go after that umbrella guy. General T said, did you listen to the song called Boone I wrote and sent to your email? I have it pulled up, General T, but I didn't want to listen to it last night because I wasn't emotionally prepared to, but I've got it on my timeline, so I'm going to check it out. Thank you so much. I appreciate you. Sammy said, I would hate for this case to go to a male judge like Duty and believe her BS because he just don't know how a female body works. Yeah, maybe that's what they're hoping for. Can we get this to a judge who doesn't understand female anatomy? Is there a virgin judge out there? This conduct, while sufficient to warrant additional other relief, including but not limited to a new trial. Oh, we already said that part. In the event Judge Mata disputes the allegations set forth below, Laura requests that the family court presiding judge set this matter for an evidentiary hearing pursuant to family law rule, and that upon doing so, the court approve the issuance of subpoenas to Judge Mata and her father, Mr. Howe. So they want a different hearing. They are literally finding new ways to just clog up the system. JH sent a $7 Canadian super chat that has no merit. They can only file for an appeal. To be quite honest, I don't know how it works, but I'll take your word for it. Because you've got super chat money and you sound smart, because only smart people send us super chats. Daily Dysfunction said, Heard couldn't touch Tug. I highly doubt Low can. Can't touch this.
Dave coming with receipts.
Case summary background. The facts of the matter are set forth in detail in the affidavit of counsel submitted here within. In short, this case began as a simple paternity establishment action with one uncommon wrinkle. Respondent Clayton is a minor celebrity as a result of his appearance on the reality TV dating program called The Bachelor. Clayton did not merely appear as a contestant on The Bachelor, he was the star of his season, appearing on the show from January to March of 2022. And then they showed a very likable Clayton playing with puppies. If you're trying to make this guy look to be not credible, don't show him with cute little puppies. Laura claimed she had a one-night encounter with Clayton in Scottsdale on May 20th, and she learned she was pregnant 11 days later. Laura claimed she tested positive for her pregnancy on 5 separate occasions before this case was filed. May 31st, June 1st, June 19th, June 21st, and July 25th, and August 1st. What about July 2nd? The first test taken on May 31st was an at-home test. The next test on June 1st, Laura went to a Banner urgent care. The test at Banner was also positive. After Laura informed Clayton of these positive tests on June 19th, Clayton invited Laura to his home to discuss the situation. Upon arrival, Clayton surprised Laura with a home pregnancy test he had purchased, and he demanded she take the test immediately in front of him. If you don't mind me talking fast through these parts, it's because we've heard this a million times. After the parties were unable to reach an agreement on how to deal with the situation, and after 2 more positive tests, Laura filed this action. On August 1st, upon filing in through the president, this matter was assigned to Honorable Julie Mata. On August 21st, Clayton filed a pro se response denying paternity. In his response, Clayton claimed only oral occurred between the parties, not intercourse. And he further alleged this entire petition is made up by Laura. Laura claims that while the matter was pending, she had a blood test done on October 16th, which confirmed yet again she was pregnant, but the test results suggested the pregnancy was not viable. It was likely to end in miscarriage. About a month later, on November 14th, Laura was seen by an OBGYN facility called MomDoc, where it was confirmed she was no longer pregnant. This leaves out so much to the story. So much to the story. And all you can help think, or I guess he's hoping the new judge sees this side of the story and doesn't ask questions, because this is leaving out, and as we all know, so much. T3 said, isn't it linked in the filing for them to review? Now it's deleted. I don't know. What does that mean? Diane Boston said, oral, they only chatted? Yes, they chatted with their mouths. Or at least she did. Quite the talker. Claude said Gingras had to add visual aids to jack up the page count. Oh, wait till you see it. After learning she was no longer pregnant, Laura filed nothing further in this case, and she took no actions to prosecute the matter any further because Laura is not an attorney. She was not familiar with the process of seeking a voluntary dismissal. On December 4th, court administration issued a notice placing this matter on the inactive calendar and scheduling the matter for dismissal on February 2nd. So they are lying they are rewriting the story. So, luckily they can't do that. But if you only read this, you'd go, oh, boy, it sounds pretty reasonable. But of course we know she claimed she was pregnant far longer than that. Shortly, and she also, lied about the HCG levels. Lying by omission. Oh, they're lying by lots of omission. Kelly said, well, we do know she literally can't shut her mouth. Whether it's filing court documents or swallowing Clayton's pride. Shortly before the case was due to be dismissed for inactivity, Clayton retained counsel Greg Woodnick, who appeared in this matter for the first time on December 12th. Mr. Woodnick immediately filed several pleadings, including a motion to amend Clayton's answer to the petition, a motion for Rule 26. Notably, Mr. Woodnick filed these pleadings without making any attempt to meet and confer with Laura as required by family law rule. He moved for Rule 26 sanctions without ever providing written notice to Laura or her right to amend or withdraw her petition as required by family law rule. I wonder if Woodnick didn't want to meet with her because she accused him of something crazy in her conversation with the judge in the previous case. The comment section's going nuts. Dingus is forgetting all the other evidence Laura submitted with the other hearings. Yeah. Chris Jenner said, I saw a comment that said Gingras is trying to expose Mata for inappropriate ex parte communication by sending an inappropriate ex parte communication. Oh, absolutely. Shortly thereafter, Laura retained counsel Alexi Linval, to the Alexi, who appeared on December 22nd and filed a motion to dismiss with prejudice. Days later, Ms. Linval withdrew from this matter when she was able to find out that Laura was lying. I added the last part. Confusingly, on January 25th, Judge Mata issued an order granting Laura's motion to dismiss. That ruling, the court indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Judge Mata then set an evidentiary hearing on those issues for June 10th. Oh my gosh. The undersigned was first retained to represent Laura on March 25th. After appearing in this case, undersigned counsel quickly discovered that Mr. Woodnick filed the Rule 26 motion for sanctions without first consulting with Laura, and the sanctions motion was filed without giving the mandatory 10-day written warning. So it goes on and on about the things he's literally been complaining about forever. Unfortunately, that request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment on the pleadings as to the issue of sanctions on May 10th. On May 29th, a minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motions for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn and despite no other sanctions or fees motions pending, the case proceeded to trial on June 10th. On June 17th, Judge Mata issued an order finding in favor of Clayton as to substantially all issues in the case in awarding attorney's fees in the amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in this case, as well as 2 other matters, and that she may have committed perjury in this case or elsewhere. The order is not entirely clear. Based on those findings, Judge Mata referred this matter to the Maricopa County Attorney's Office.
Dave coming with receipts.
MG Law said, notice for the sanctions was proper. Woodnick just withdrew it to be nice and tried to avoid exactly the behavior Fungus has engaged in since then. Fungus. Oh, I love the names. Terry said, Dave, even if a new judge was assigned, the trial stands. The new judge would just take over the motion of attorney's fees. After this, they would have to file appeal. The chief judge will not reassess. Yeah, I mean, just wild. It's almost just like they're burning money. Since does he have like an AI person filing these motions? Which, by the way, if you can program AI to do this, it's going to make the judicial system so painful. Legal standard. Family law rule provides grounds. A party seeking a change of judge for cause must establish grounds by affidavit as required. The party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. Who is he? It is important to note this rule does not contain any express time limits for seeking a change of judge, but Arizona courts have read that statute as containing an implicit limit. A party cannot ask to disqualify a judge after a trial has begun. If a judge is allowed to receive evidence which of necessity is to be used and weighed in deciding the ultimate issues, it is too late to disqualify him on the ground of bias and prejudice. All right, so just, boring case law stuff. As explained in the concurrently filed affidavit of counsel, the grounds upon which a change of judge are requested in this case are primarily based on misconduct committed by Judge Mata, which shows her post-trial ruling contained findings that were not based on the evidence submitted at trial. Rather, Judge Mata made findings based on an improper ex parte investigation she conducted, which included reviewing information posted on the internet about the case. Until Judge Mata's post-trial ruling was issued on June 18th, 2024, less than 20 days ago, Laura did not know and could not possibly have known of the judge's misconduct in this regard. Although this single issue is sufficient to grant the relief requested, there is also evidence showing other misconduct committed by Judge Mata, including the fact she engaged in an improper ex parte discussion of the facts of this case with her father, Harry Howe. Although Laura and underside counsel heard rumors about Mr. Howe appearing at the trial on June 10th, the specific detail of exactly what occurred and proof to establish these facts was not fully known until undersigned counsel returned from his pre-planned vacation. Yeah, Sunshine, we don't want to insult the artificial intelligence. MG Law said AI still makes a lot of mistakes, so attorneys have to be vigilant in reviewing AI-generated documents. Yeah, other folks are saying, yeah, there's a lot of things she needs to get named. For those reasons, this request is timely pursuant to family law rule. Discussion. Clear and convincing evidence shows Judge Mata conducted an improper ex parte investigation into the facts. The details of the grounds for disqualification are set forth in the affidavit of counsel submitted herewith. To summarize those grounds, this request is primarily based on the fact there is clear, irrefutable evidence that Judge Mata conducted an ex parte investigation into the facts of this case, and even worse, at least one of her post-trial factual findings on a critical important issue was based solely on information posted on the internet and not based on the evidence submitted at trial. Because episodes of such brazen and blatant judicial misconduct are thankfully rare, comparable examples in Arizona are difficult to find. However, something very similar occurred. North Carolina Judicial Standard Commission's inquiry, a copy of this. That case, like this matter, involved a family court proceeding. In Terry, the assigned judge posted comments about the case on Facebook. He also used the internet site Google to find information about a party's photography business. The judge also visited the website of a party and copied a poem from that party's website, which he recited at trial. Upon discovering these facts, one of the parties moved to disqualify the judge, asking... So there's another case in North Carolina where they wanted to disqualify a judge. But why they want to disqualify Mata is interesting. Judges acting as fact finders in a bench trial are subject to exactly the same rules as jurors. A juror may never investigate facts in a matter independently. All right, so I think we can understand what his point is. There is no question Judge Mata violated this most basic core requirement of fairness. She did so by making a critical factual finding that Planned Parenthood is closed on Sunday. So is that true or not? Did Judge Mata find that Planned Parenthood was closed on Sunday? Let's just go here to all of the examples of Sunday being said and see if we can figure this out. Let's do this. Planned. So Mr. Woodnick will ask you about this Planned Parenthood. Verify that you were. So the Planned Parenthood was mentioned 26 times. Ultrasound at Planned Parenthood. Alleged ultrasound at Planned Parenthood. You knew that we were seeking your records from Planned Parenthood. Planned Parenthood. Planned Parenthood. An ultrasound at Planned Parenthood on July 7th, which you doctored to say it was from Smile, right? Correct. Let's pick up right here at 4405.
An ultrasound at Planned Parenthood on July 7th, which you doctored to say it was from Smile, right?
Correct.
Then the story changes again, and you claim that the ultrasound image should actually be dated July 2nd of 2023, right?
Correct.
So you changed the date on the ultrasound from July 2nd to July 7th, correct?
Correct.
And you utilized this altered or fake ultrasound to try to convince Mr. Echard and the court and the media that you were pregnant with Mr. Echard's twins.
This was never submitted to the court.
You're aware that Planned Parenthood has no record of an ultrasound for you, correct?
Under my real name, yes, and more.
And again, we've established you didn't provide our office with the name of that you allegedly went to Planned Parenthood under, correct?
Correct.
You never attended an appointment with Planned Parenthood in this case, Ms. Owens.
Yes, I did.
Can you take a look at Exhibit B29?
Interesting. Nikki says they're only doing this because it's the cheaper option. She'd have to pay up front for an appeal. Very interesting.
This is a true and accurate copy of our request and the response from Planned Parenthood regarding your records dated April 26th of 2024, correct?
Correct. I don't believe I've seen this, but I have no idea.
And counsel, I'm so sorry. I'll stop the clock like I've done for the others.
What?
We're going to give you a microphone because, as I anticipated, there was a problem.
Is a copy of our request and the response from Planned Parenthood regarding your records dated April 26th of 2024, correct?
Correct.
Move for the admission of Exhibit B29, Your Honor.
Any objection?
No objection.
B29 is received.
And while you've indicated today that you went to Planned Parenthood under a fake name, this letter actually indicates that you had scheduled an appointment for July 2nd, but that you failed to attend.
Correct.
It also indicates that the ultrasound image that you claimed was from Planned Parenthood was not from Planned Parenthood because it was not consistent with ultrasound images generated by their practice, right?
Not by the one in Mission Viejo. Correct.
Ms. Owens, these are yes or no questions. This document states that the ultrasound image you have claimed is from Planned Parenthood is not consistent with ultrasound images generated by their practice, right?
By that practice, but as they said, I could have been seen by another different entity.
I love that she's speaking in hypotheticals. I could have been seen.
Ms. Owens, you're well aware that this request covered all of Orange County and San Bernardino County.
It didn't cover Los Angeles, though.
So now you're saying you went to Planned Parenthood in Los Angeles.
Yes.
So you're telling us you went to Planned Parenthood in Los Angeles on the day of trial today.
Yes.
Okay. When did you go to Planned Parenthood in Los Angeles?
Exactly when I said I went.
When was that?
July 2nd.
Okay. I'd like to go back to the two SACs you passed. So again, in your deposition, you claimed you passed them in September or October, right?
Yes.
But then you changed the date and claimed that you passed these two SACs on July 23rd of 2023, right?
Right.
So some people have said that Deandra, some people have made the point, somebody made the point that Deandra said, would it surprise you to know that LA County Planned Parenthood offices were closed on Sundays? I don't see that happening. I don't see any mention of LA County. There are 5 mentions of LA County. Or of county. So I think they were just not prepared to discuss Planned Parenthood in Los Angeles. So I'm just going to look through the right here and see.
From Laura, are you aware that that was altered?
Yes, I am.
Laura claimed it was anonymous and from Planned Parenthood. Any thoughts about that?
Patients cannot be seen anonymously at Planned Parenthood. Planned Parenthood, having been a former medical director of Planned Parenthood.
I totally agree. So Gingras is almost trying to get them on the fact that Laura brought in new information.
PPFA, which is our national...
I don't know what the rules are, but if you bring in new information, you should be able to verify that.
Guidelines require identification at the time of a visit to confirm the identity of the patient. The patient can't be seen anonymously.
Thank you. Laura claims she was pregnant with twins. Anything you reviewed in any of the medical records confirmed that Laura was pregnant with twins?
No.
Laura claimed that the twins were boy and girl gendered. Anything that you reviewed that confirms that?
No.
Do you recall reviewing the October 16th HCG test? I think it had a 100 or 3-digit HCG level on it.
I do.
Are you aware that there's actually 2 other versions of that exact same test in circulation?
I've heard that. I have not seen them.
If I told you there was another version with 1,000 times higher HCG level, would that cause you concern?
Yes, it would.
Are there alternate causations for a positive HCG test, as we have here?
Yes, sir.
Did you review I'm going to skip over the photos. Did you review Dr. Medchill's report?
I did.
You're aware that Laura first claimed she miscarried in September or October, and then the photos that are in the report indicate that it happened in the 3rd week of July, correct?
Correct.
Pursuant to Dr. Medchill's report, he concluded, do you agree with his conclusion that the data here warrants that Laura was 99% pregnant?
No, I do not agree with that assessment.
Do you agree with Dr. Medchill that the record confirms, this is from his report, a May 20th conception date?
Absolutely not. There's no data to confirm a conception date at this point that would require an ultrasound dating of a pregnancy.
Professor Deans, thank you. Judge, I just
got a text from someone that said, Dave, for the love of God, stop playing into their game. What are we doing? What are you talking about? So anyway, let's go back to the, what he's saying here. Furthermore, although Judicial Conduct Rule 2.9c does allow a judge to base findings on, but I mean, I appreciate, people sending me messages, but like, I'm at work right now. What are we talking about? What are we doing here? It blows my, yeah, it could be in the report. I have no idea. It's really not that big of a deal. Let's get through it. We have a lot to get through. Furthermore, although judicial conduct does allow a judge to base findings on facts which may properly be judicially noticed, the business hours of Planned Parenthood location in California is not a fact subject to judicial notice, nor did Judge Mata claim she took judicial notice of that fact. This exact issue was discussed. So they go through hypothetical. Again, because such blatant misconduct is rare, there is no direct control. Okay, so it's rare to see misconduct. So why does he think he's seeing it right now? He kind of makes the point that there is no misconduct. These facts demonstrate that Judge Mata did exactly what the rules expressly prohibit. She conducted her own independent investigation into the facts and then used the results of that investigation to reach an adverse decision. This is a profound violation of Laura's rights. Yeah, this is so crazy because, the judge could just I mean, we could get into all the different hypotheticals, but what you surely are not doing is proving that the judge did her own research. Melanie said, is Chase J. Jones in this chat? Could be. Chris said, who the hell has your phone number and is talking to you like that? I don't know. I'll say this. If people do have my phone number and text me, can you be extra kind? Like, did people not realize how they come off? You know what I mean? Like, chill out, folks. Chill out. Ugh. Other evidence supports a finding of judicial bias. The law is clear. A single instance of misconduct by a trial judge is sufficient to establish bias and require disqualification. As explained above, evidence proves Judge Mata undertook an independent investigation into the facts, and by doing so, she manifested bias sufficient to require her disqualification. What's so funny, too, it's like, because the judge knew my client was lying, they must be biased. That's really what it comes down to. He tries to prove something and like take a leap of logic, and then afterwards, everything he says is based on the quote unquote fact, which is really just his leap to logic. So they go into this other thing here, where, gosh, all right, we only have 20 minutes. Fuck. The fact that her father was there, but this is the interesting part. So they go into this idea that the father was there, which maybe he was, maybe he wasn't, the judge's father. This shameful conduct not only violated Laura's rights, it raises serious questions regarding Judge Mata's fitness as a judge of the Superior Court. Any reasonable objective observer in Laura's position would be justified in wondering, was my case fairly decided based on the evidence, or was Judge Mata simply trying to impress her father? Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee hee. By the way, I'm not considering Laura to be a young woman. She's a woman. Assuming the published allegations of Judge Mata are true, as documented, this proves Judge Mata separately violated Rule 2.9 of the Code of Judicial Conduct. Judge Mata's blatant, pervasive disregard for her ethical duties and her disrespect for Laura's fundamental rights helps explain the judge's numerous adverse rulings during the actions. So he's calling all of the judge's rulings adverse because he's so bad in his representation of his client. McMuffin said it's annoying that Laura's own perjurious statements on the day of trial are being used. Binky said, is this real life or is this just fantasy? We are stuck between dingus and what we call reality. As a general rule, don't make me rap. Yo, here we are. Let's go. Here we are, Gingras in the house. Fungus, dingus. Everybody want to know if we got it going on. And we do now. Yo. Here we go, don't text me. Dave, for the love of God, stop playing into the game. I think that text is kind of lame. Gonna play into the game. We doing it for fame. Gonna get that breadstick money. Gonna get it all day. Butter it up, honey. Gonna get it each and every way. Get it till the end of the day. Get it till I'm going gay. Get it if you want it way. Here we go. Gonna carbo load. Okay, I gotta go. I gotta finish this. Let's just keep this party going. And the vast majority of disqualifying. So basically, it just says he wants her disqualified. In conclusion, for the reasons stated above, Laura respectfully requests a family court presiding judge, Honorable Rhonda Fisk, review this matter and find that grounds exist to disqualify Judge Mata, and to promptly reassign this matter to a new judge. Open your eyes, look up to the skies and see. I'm just a poor YouTuber. No, we're not poor. We're doing just fine. We're living the law of abundance. So here's an affidavit of David Gingras in support of petitioner's notice. I, David Gingras, swear and affirm under penalty of perjury. My name is David. I'm a U.S. citizen, reside in the state. I'm over 18, even though my girlfriend's not. I'm an attorney licensed to practice. Well, not in today's world, but get into that story. I am an attorney licensed to practice law in the state of Arizona. I'm an active member in good standing with the state bars of Arizona. Yeah, right now you are. This affidavit, let's check back in a few months. Who's Jenna? Oh, Jenna said, I'll pay to stop rapping. Put your money where your mouth is, Jenna. Send that super chat in. If you send me a super chat, it's only one click away. All right. I've caused to believe on these grounds. I do believe that on account of bias, prejudice, and other interests, the judge currently assigned to this matter is unable to act fairly. For these reasons, lower request that the family court presiding judge find that Judge Mata is disqualified from all further proceedings in this action. Case summary. This case began with a petition. In the petition, okay, so we got all of this. I tell you what, let's just go to where he mentions me. How about that? Let's go to where he mentions me, ya boy, old Davey Homeslice. So here it is. I am mentioned 21 times. YouTubers, Dave Neal and Megan, when I post, in an attempt to respond to some of this one-sided narrative, acting on Laura's request, and with her written acting on Laura's request, I have occasionally posted comments about this case online, primarily on my website. So basically, she's paying him for her PR work. Laura is disqualified. A bona fide lawyer in her right. She's gonna lie all she needs to every day. Biggie says more super chats today. Here we go, everybody wanna know what we got it going on. Gonna give it to you nice and slow. 211 pages, this is the story. Clear your schedule, we gonna be here till the morning glory. Gonna give it to you. 21, that's right. Savage. 21 times were mentioned. So he says, he posts comments at her request. Gingras, why you gotta be Laura's bitch? Is the money worth it? I had a lawyer I know say that Gingras probably only got paid $15,000 for this. They said probably he's owed a lot more. That's my guess, is she's owed him more money, so he has to keep on playing this game, almost like a Ponzi scheme. That's my guess. So he says, when I post comments on either Twitter or my personal website, members of the public can, and often do, post responses, comments, replies. This point is important for reasons I will describe further below. Oh, we're so excited. The purpose of these comments has been primarily, if not exclusively, to respond to information being circulated about this case by Clayton, his lawyers, and or his fans and supporters. Don't we have a judicial system so it plays out? In addition to social media posts from his fans, Clayton himself has been extremely personally active in publicly promoting this case, giving countless media interviews. I wouldn't say they're countless, in which he tells his side of the story. Clayton's attorney, Mr. Woodnick, has published statements regarding this case, including a press release issued on March 7th, in which Mr. Woodnick accused Laura of fraud, suggesting she had been accused of fabricating pregnancies and doctoring medical evidence as a means to extort relationships several times dating back 10 years. T3 said he wasn't getting paid to blog. That's a great point. Winks with a $20 super chat said, thank you for continuing to cover this madness. I'm just baffled at the disrespect he has in his speaking of Judge Mata. I don't have words. Well, you've got super chat bucks and we appreciate them. Chris Jenner said, someone said Gingerbread's website says he only charges $275 per hour. Yeah, my lawyer charges $800 an hour. My lawyer makes more than you. The problem, he just takes the bait. He takes the bait on all of the sort of like, see, like what we're doing is we're doing our job. which is to shine light on the bullshit, right? We're doing our job. But he takes that bait and he takes it personally. Do I take him personally? You know, maybe sometimes, but I can not take something personally and still find it offensive. Does that make sense? So I'm not going, oh, this guy's the worst. I'm going, dude, what a joke you are. You know what I mean? It's almost like apathy is worse than anger. Like if this was a guy that I say knew in real life, I would avoid him like I would just, okay, cool, weird. And if that is me being mean to him, it's like, get over it. When I post comments on either Twitter, okay, before discussing the specific issues and conduct given rise to Laura's request to disqualify Judge Mata, it's important to understand some of the other participants who will be mentioned further below. No, it's not. It's not important to understand us. We have nothing to do with anything that's going on in the court system. Two such participants are individuals named Dave Neal and Megan Fox, which, by the way, is so great because his initial comments were like, Megan Fox, I can't even stand to know who she is. You know her name now, bitch. I'm just reading your comments. Beaky said, being incredulous doesn't mean you have to be offended. It doesn't have to mean you're offended. Absolutely. I do not personally know either Dave Neal or Megan Fox, but during this course of this proceeding, I've become generally familiar with them. All right, well, don't pretend you tried to get me on the phone. You wanted to talk. You know, don't pretend like you are just becoming familiar with me. You've studied me. According to this YouTube channel, Dave Neal is a stand-up comedian who lives in Tennessee, which, I mean, okay. Dave also creates and publishes videos on YouTube nearly every day. Dave's videos often focus on The Bachelor and people like Clayton who have appeared on the show. If you work hard like Dave, you also can have a successful YouTube channel, is what he's trying to say. Over the last several months, Dave Neal has obsessively published hundreds of hours of videos regarding this case, as reflected on his YouTube channel below. These videos are generally almost universally devoted to viciously attacking Laura, and often me, and to proclaiming that Clayton is a victim who deserves justice. I would like citation as to how I'm attacking him. Mocking. Are we going to say that mocking is attacking? Is a free speech lawyer going to cry because he's being mocked by a comedian online? What? In the spineless? Come on, you're stronger than that. You're a lawyer of like 20 years. Let me ask you this. You're a lawyer. We're going to go to the big shot. You're a lawyer of 20 years. And you're revealing that you feel like you're being viciously attacked by a YouTuber? A comedian who lives in Tennessee? That's all it took to get to you? What? I'm wearing my shorts today. You ever been viciously attacked by a guy wearing shorts? And I don't even abide by the rule of like an eye for an eye, you know, makes the whole world blind. But this is a game he wanted to play. This is a dance he wanted to dance. We're just doing him better than he is. Tootsie said, a free speech lawyer whose claim to fame was defending a revenge porn site. I don't even bring up any of his past, like, whatever. This is all that matters now. Tiffany said, clown face emojis. How bizarre. Someone like his client who's so recklessly doctoring medical information, lying to my face, and I'm the one who's viciously attacking her. If by viciously attack you mean viciously pursue truth, then you're right. This is an insurrection of truth. It's an insurrection of Yo. Here we go. everybody want to know. Sit down in the booth. It's an insurrection of... Over the last several months, Dave has obsessively published hundreds of videos regarding this case. Yeah, we need to publish more so we can get that number up to thousands. I'm slipping, as reflected on his YouTube channel below. These videos are generally almost universally devoted to viciously attacking Laura, and often me, as to proclaiming that Clayton is a victim who deserves justice. In opinion. Notably, Clayton has personally appeared in several of Dave Neal's videos. It is clear that Dave Neal is not covering this case as a neutral journalist, but rather as a passionate, obsessive advocate for Clayton. And then they share some of my greatest work. I mean, really good stuff here. Really good stuff here. Fake cancer. Former lawyer addresses her lies. Really good. You know, vacationing. Tootsie's Tidbit says, for him to cry attacking for mocking is ludicrous. Yeah, mocking is a great tool we have to shame people who did stupid stuff. Another YouTuber following this case is an individual using the name Megan Fox, who I believe is a resident of New York State. I do not personally know Miss Fox. I believe that to be a pseudonym. It's not. I, of course, have a copy of Megan Fox's driver's license. That's her real name. But she has contacted me via email several times during this case, and I understand that she claims to be a journalist who publishes stories on an extreme far right-wing news website. So he's trying to make this political. He's trying to make it gender-based because I'm a guy attacking a vicious, he's trying to make it political. She's got her father claiming anti-Semitism. Roy says we need to file defamation lawsuits against them. Like Dave Neal, and by the way, all we can do is continue to grow the channel. My goal is to make as much money for my family and to defend myself so that I'm not bullied and pushed around by court systems. And we're having the sort of the framework to do just that. Dave Megan also creates and publishes videos on her YouTube channel. Like Dave Neal, Megan Fox is a passionate supporter of the cause. Her videos are overwhelmingly devoted to exposing and destroying Laura while promoting the narrative that Clayton is an innocent victim who deserves justice. Dave and Meg are mentioned because they are relevant to the issues raised herein. This is so because they attended the trial held in the matter on June 10th, and after the trial, both appeared on video claiming to have or speaking with others who claim to have direct knowledge regarding certain improper conduct committed by Judge Mata during the trial. That's not true. So someone came up and said that they talked to the judge's father. Nothing illegal with that. Summary of pretrial, and again, didn't delete it. You can go watch it. It's up there. Shortly after I became involved in this case in late March, several events occurred which initially caused concern regarding the bias and lack of neutrality. Laura's prior counsel did not prompt. Okay, let's just go back to more of where I am mentioned, because that's what we care about. Prior to trial, I learned that Dave Neal and Megan Fox were planning to attend the trial in support of Clayton. It is my personal belief that courts are publicly funded fora. Trials and legal proceedings belong to the public. That's not a belief, idiot. That's a right. It's my personal belief that you shouldn't kill each other. Yeah, duh. It is my personal belief. I further believe as a matter of law that members of the public have a near absolute right to observe and report on events which take place in court, so I viewed the public interest in attending and observing the trial as a good thing. However, when I arrived at court on the morning of trial, I was surprised to see dozens, if not hundreds, of people waiting to watch the trial. 50. Before trial began, Judge Mata spoke to counsel. Yeah, I mean, there was SWAT there. There was undercover police there. System X with a $7 Canadian super chat, only $2.75 an hour. So Gingras is on the D list. Oh, funny. That's funny. While I was on vacation, Laura contacted me and told me about some extremely disturbing information being shared on social media by Dave Neal and Megan Fox. Specifically, Mr. Neal and Mrs. Fox appeared in several live streamed and other videos in which they claimed Judge Mata's father was present in the overflow room during the trial. By the way, I was outside. The only time I went into the courthouse was to use the bathroom. I couldn't tell you if the trial was on the left side of the hallway or the right side. I had no idea. $5 from Jasmine Winters. In 2010, a federal appeals court ruled it's acceptable for a judge to do an internet search to confirm an intuition about a matter of common knowledge. Wow. Where did you get that from? In 2010, federal appeals court rules it's acceptable for a federal appeals court rules it's acceptable for a judge to do an internet search to confirm an intuition. So I know I got some of that wrong. A federal court ruling could encourage judges to Google. A federal appeals court said it can be acceptable for a judge to conduct an internet search to confirm an intuition about a matter of common knowledge. So a matter of common knowledge would be whether or not Planned Parenthood was open on a Sunday. That's a matter of common knowledge. That's not Googling whether or not you think Joe Biden's got Parkinson's or something that's debatable, right? Miriam says, keep fighting the good fight and speaking your mind and promoting the truth. You probably won't see this, but you are supported in killing it. No, Miriam, thank you so much. I soak in, I sunbathe with all of the amazing comments that continue to root me on. All right, T. Curry said, it is political. No. So this is not political. We conservatives know Laura is lying. We have watched months of her attacks and made up tests. Only liberals, for some reason, want to buy into her BS. That's not true. Find me a liberal buying into her BS that's not on her payroll or her father. That's T. Curry. That's a ridiculous statement. You realize I'm a liberal person. Liberal-minded, I should say. Whatever that means. That's Gingras isn't using this politically for any reason other than he's trying to win. Now, you might say that that there have been no left-leaning news sites covering the story. That's something you could say. Oh, Chris said I missed one of her super chats from earlier. I'm sorry. Chris said, did you see Gingras Bread posted a live of me and others on his YouTube channel? He deleted. Shortly after, Lauren made fun of him for it on her live last night. Why would he do that? How bizarre. How bizarre. How bizarre. All right, so. All right, I have to get. Oh, shit, we have to get going. I'm going to be taking this over onto the Patreon in a few minutes. As usual, this may be the mere fact Judge Matz's father attended the trial, if true, is not the primary concern. The concern is that according to comments from Dave Neal, Megan Fox and others appearing on video with them, Mr. House stated Judge Matza discussing the facts of this case with him prior to trial. One such specific statement, I don't know what's going on. One such, check. I don't know why I'm hearing feedback. What is all, and by the way, this is all hearsay. No one's actually heard from the judge's father. I have no idea. Someone came up to me, again, what am I supposed to do? Someone came up to me and said, the judge's father was in there. And then as reported here, I comment, hold on, we don't need a mistrial. I said that within a quarter second of them saying that. And I didn't delete it. I'm not the judge. I don't get to decide what's mistrial worthy. Okay. Kelly said, $5 super chat. I feel like I haven't seen you in a bit, Dave. Missed you. Oh, hey, Kelly, how are you? Thank you. All right, let's wrap this up. I understood those remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding comments they claim to have received from Judge Motz's father, because he believed they would expose judicial misconduct and bias. I responded within an eighth of a second, like I said. I'm not a legal expert. I just know what the truths are. Haley said, when you made that mistrial comment, I instantly took that as a joke. Yeah, the comments live online. You can go see it. Raised concerns regarding Judge Ma's father and alleged statements made by Dave Neal. Alleged statements. And then the next time they mentioned me was actually in the deposition where she admitted to fraud. So there it is. The question, is the lawyer obsessed with me? Well, maybe just by proxy because Laura is. All right. Well, all good, folks. All good. Here's what's going to happen now. Now we are going to move to the Patreon. Gonna move to the Patreon. I'm going on Patreon. Let me do this. I will do one last look to see if there's any information regarding the bill that we're waiting to come in. We're waiting for the bill to come in. If you are on Patreon, I did post yesterday. I posted yesterday. Everyone can guess how much money the bill's going to cost. We got some good guesses. Let's go. Let's actually go to it right now. Yesterday, all my troubles are so far away. All right, here it is. Clayton's legal bill is due today. This was yesterday. So my guess is the bill is going to be $195,245. I do think I'm very low here. Oh, Tiffany said, can you check the GoFundMe? Yeah, I'll check that next. So Hellcat said 338,000, Shannon 206,000. We had 130 comments. If somebody guesses the exact amount, I'll buy a date night, whatever that is. 239,456. So very specific guess. And I still don't know what it is. We're still waiting. We'll find that out when we do. And then lastly, let's check out the GoFundMe. Give, send, go. So we're going to go to the birthday fund amount. Let's go find it. We've done 2 campaigns. So here it is. Unbelievable. We wanted to raise $2,500 and we've raised $3,643. Proud. Very proud. General T said, play the song, Dave. I'm not ready. I'm going to play it on my own time. I don't want to play it in front of people, but thank you. Deb said, I think their obsession with you is far greater than any obsession you have with them. Oh, I'm not obsessed with them whatsoever, right? I mean, I'm just doing my job, right? I'm pursuing the truth. But I will play it, General T. I'm just not emotionally wanting to dive into old Booney Boy right now. Oh, Wink said everyone stop by MG Law tonight. Yeah, go stop by MG Law. We stream on like opposite times, so for anyone who needs an evening stream. Denise said, Dave, bring Tasha on so that you can let people know you're not available. Yeah, I mean, Laura, I'm married. Leave me alone. Pamela said, check out Dr. Dean's deposition. The video that Lowe and DG showed part of a report. Yeah, I don't know where that is, but I'm sure someone will find it. Well, that's going to do it for me. Again, I am going live on Patreon. Literally. Actually, you know what I'm going to do? I'll stay live with you guys right now as I go live on Patreon. Just so you can see that I'm actually going. So here it is. I don't know where the thing is. Start streaming. Manage broadcast. We're going to call this Work with Dave Part 2 now. And then I'm going to be going live. It's going to be unlisted, which means only the Patreon audience is going to get it. So we are live right now. All right, that's going to be it for me. I'll see you guys over on Patreon. Bye, everybody.